Hello again and welcome. I'm Whitney, and I'm so glad you could join us for today's session, Estate Planning 101. Estate planning is so important no matter where you are in life, whether you're just starting out, raising a family, or planning for retirement. Today, I'm excited to introduce Craig Parker on the call with me. He is the Assistant General Counsel at Trust and Will. Craig has over 25 years of experience as an estate planning attorney, and he's going to walk us through the essentials, what estate planning really means, the key documents to know about, and when it makes sense to update your plan. As we go along, please drop your questions in the chat. We'll save time at the end to answer them. One quick note before we dive in, this webinar is for educational purposes. We will not be offering legal advice today. Craig is going to keep things broad and practical, so you'll walk away with a clear understanding of the fundamentals. And with that, I will hand it over to Craig to get into specifically what we'll cover and talk a little bit more about his background.
All right, thank you very much, Whitney. So today, while we can't cover everything, we want to at least give you a really solid foundation of the basics of wills and trusts, and maybe some of the milestones in a person's life when they might be thinking about updating their estate plan, or why they should be thinking about that, and what might trigger somebody to make changes to their plan. And understand that estate plan is something that everyone can use, whether you have assets or don't. Most of us think of estate planning only for the wealthy, or what we think of as having a lot of assets, and for people like me with gray hair, right? In reality, it's not just for older people. Estate planning starts with anybody that's an adult 18 and over, because estate planning includes things like health decisions, if you are unable to communicate with your doctor, and about all the fundamentals about providing help to the people around you to be able to help you in times of illness or sickness, or times, the most difficult times of our lives, to make them easier. Next slide. So this is a little bit about me, pictures of my family. I have been an estate planning attorney for 25 years in California. I'm a certified specialist in trust and estate law. I have two daughters. I'm the father of two daughters who are now adults, and one of my daughters is married now, and I have one granddaughter there, Poppy. So I think, like a lot of you, when we think about estate planning, we think about the people we love, the people around us. We might be close friends and people that are not biological family, but are close family, and others. Like a lot of you, I'm sure on this call, I've had my share of difficult experiences within my family. My wife, Jill, there recently was diagnosed with colon cancer, and we battled that together for like 14 years before she passed away at the young age of only 55 a couple of years ago. And the documents that I'm talking about in estate planning, they can't take away all of the grief and the difficulty that all of us go through, but they certainly made it a lot easier. I am so grateful that we have those kind of documents, and I'll talk today a little bit about how they help my family. I've also helped, obviously, hundreds and thousands of others and their family in those circumstances, but it's always gives you a whole different perspective when it happens to you. And I am grateful to be part of Trust and Will, and our mission is to let every single family in the country, no matter how much you have in assets, be able to have an estate plan. So we are looking for ways to democratize it, to make it accessible and easy for everyone and affordable. And today we're going to talk about all the ways that we're doing that. Next slide. So who are we as a company, Trust and Will? So We are on a mission, like I said, to help every family leave a legacy. How are we doing this? We're making estate planning, and like I said, more accessible, affordable, and easy. And we've helped over 500,000 families, and our process has saved them more than 70% and what it might cost to go sit down in a lawyer's office. It also helps overcome a lot of those barriers. Not only is it less expensive, but it's very intuitive and easy. And it's something you can do and start in your own home, on your own computer, or even on your phone now. You can start with us, setting up your estate plan and working at it in the evenings, on the weekend, sitting down with your spouse, if you have one, and working through those questions. Next slide. So estate planning is about future proofing, about legacy building. For me, it's really about thinking about the hardest things we have to think about sometimes, which is what happens when we are unable to act for ourselves. Maybe we have a stroke or we have dementia and we start to not be able to handle our finances or make medical decisions. Well, our loved ones are going to come and they're going to want to help us. But if we don't empower them by giving them authority to talk to doctors on our behalf, to make decisions on our behalf, they're going to be stuck in a situation where they're going to have to spend thousands of dollars going to court, trying to get authority to do something that we could give them authority right now to do. So whether we're 18 years old or older, we're now adults, we need to be giving the people around us, our family and friends, some tools in case something happens to us. Next slide. So what's part of estate planning? Some of these documents you're really familiar with, but the basic estate plan includes a will. It may include a trust, and includes what we're calling healthcare documents. These documents are there to try to help in situations where you either pass away or you just become ill or unable, even if it's for just a few months, for somebody to be able to help you with your finances or your health decisions. Next slide. So let's talk about the purposes of some of these documents and how we would use each one. So we've all thought about a will. Most people are most comfortable with a will because we've seen about it on TV and movies. It's been around for a long time. It seems fairly user friendly in that we know that it's a document where we can say who gets what when we pass away. But a will is more than just that. Some of the important things about a will is that you can actually name in a will who you want to be guardians of your children. So in the situation we don't like to think about, that neither of us are around, neither us or our spouse are around, who would care for our children? And I know that almost all of us would have close family and friends that would step up and want to help, and they would. But if you don't nominate someone and do a nomination in a will, they're forced to go to court, and the state decides, a judge decides who that person may be. And I can tell you, doing this 25 years, unfortunately, and watching a lot of people who don't have these documents in place, and they call my office and I end up in court with them, that sometimes the person that steps forward to want to be the guardian of your kids is not always the person you might have selected. We all have those people in our family who are the ones who want to take charge. Maybe they're the loudest. Maybe they're kind of the pushier. That may not necessarily be the person you choose. But I can tell you that often those are the people that go into court, spend the money, and want to become the guardian. So if you want to have a voice in that, there's only one way to do that, and that's to put it in writing. So a will can be really important for that. What about if you have pets? A lot of us have pets that we feel like are our family, right? And we worry about them. If something happens to you, what happens to your pets? Again, it's very important to legally put that in writing. And a will can state who's going to receive your pet, who will be caring for your pet. And you can have alternates if that person's unavailable. Same with the guardians. It's wise to always have backups. It's also wise to have one person who's in charge. So naming several people, you think sometimes that'll solve or make things less contentious or somehow solve that problem. It's really not the case. Honestly, naming one person where the buck stops with them, even after they confer with everybody, and you can encourage them to do that, having somebody who can make the final decision is critical, because if they can't decide, you end up in court with a judge anyways, and all your documents didn't serve that purpose that you wanted, which was to avoid that process. So name somebody, name an alternate, think about those people. That's what the purpose of a will, not just your stuff, but also these important decisions. Also, your final arrangements. It's a perfect place for you to state, do you want to be cremated? Do you want to be buried? Do you want to be buried somewhere specific? Do you have specific feelings about that? If you don't, that's okay too. But who's going to be in charge is really critical. So giving somebody legal authority to either execute or do the things that you ask them to do, which is bury you in a certain place, or to make that decision. Giving somebody that authority is critical, because when it comes to that point, if there is uncertainty and no one has your authority to do it, again, you could end up with your family and friends before a judge who doesn't want to make those decisions either. And I've been there too many times. So this is a simple document. It doesn't have to be long. It doesn't have to be complicated, but it sure is essential. Who needs it? Everyone who's over 18. Yeah, but I don't have anything yet. I don't even have a pet yet. You don't, but even the things that you start to acquire and the simple things you have in your life can be dealt with a simple will. Next slide. Now we move on to what more of people are asking about. What about a trust, right? So everybody asks, what's a trust? Let's talk about the basics of what a trust is. So a trust is a written agreement in writing between three different roles, I'm going to call them. Sometimes they're different people. Sometimes they're the same people. The first one is called a settlor. The settlor is the person who owns the property. You're like, okay, that's me, right? So you're the settlor. You're the one that owns the property, and you are going to put that property into a trust. Unlike a will, that is a document that you're more familiar with, that you write, that has nothing to do with anything until you pass away. A trust is more similar to setting up like a business or a corporation. In other words, you're going to actually retitle and put your money into a different account. It's going to be an account that has your name on it, but your name as a trustee. So with a trust, you have a settlor, which is the person in the agreement who agrees to put the property in, which is usually yourself. The next person you have is a trustee. That's the person who manages the company, the CEO. You usually are your own trustee at the beginning, and then you name your next trustee. Who's going to take over after you? Maybe your spouse, and you are the trustees. When one of you dies, the other one is the trustee. But what about when they die? So then you're going to name somebody. And again, honestly, it doesn't solve the problem. Just name everybody or all 6 kids. You really need to have somebody that's in charge, somebody who's going to make sure things happen. And you want to have an alternate, because that person may not be available. They might be sick. They might be in the car with you when you have that accident, because these are people you trust. You can even choose, if you can't think of somebody, it can be a close friend, can be a professional. There's professionals that act as trustees. That's their job. Trust and Will is even offering a program now, and others places where you can get a professional corporate trustee. So there's a cost to that. Yes, but sometimes the cost is worth it. Whoever acts as the trustee, ultimately, when you pass away, has the right to be compensated for the work they do, okay? To marshal all the assets, to pay the last debts, to get the taxes paid, and to make distribution the way you've set forth in the trust. So we've got the person who gave the assets, the settlor, the trustee, and finally you have the beneficiary. So 3 people. The beneficiary in the beginning usually is you. So it's your money, your assets, you're in charge as the trustee, and you're the beneficiary. How long are you the beneficiary? Are you the beneficiary when you get sick? Well, yeah, I really need it then when I'm sick, right? You're the beneficiary of the trust until you die. When both you and your spouse die, you name who's going to be the beneficiary after that. Maybe it's going to be all 3 kids equally or whatever, a charity, right? But the beneficiary at the beginning is you. So this agreement is in writing. And as soon as you execute it, you have to then fund a trust, and it begins operating day 1. A will does not. A will comes into play when you die. A trust operates while you are alive. Sometimes the reason why people call them living trusts. It's something that you start while you're alive, and it makes the transition easier because when you have a will, your will has to go to probate. When you have a trust, it does not. So we're going to go on to the next slide. So let's talk about the differences, right, between a will and a trust. So the will is something that everyone should have if you're 18 and over, and it can serve a lot of people. Maybe that's all you'll ever need is this will. They're very powerful documents. We talked about you can name a guardian if you have children, super important. Somebody to take care of your pets. You're going to say where you want, who you want to get what. You can talk about your final arrangements. But at the end of the day, the will, when you die, has to be read by a probate judge. Sometimes if your estate is small enough in value, okay, so if you're just starting out in life and maybe you don't have a lot of assets yet, they won't have to go through the probate court. So there's like summary proceedings that you can use your will with. But generally, most states, once you get over about $150,000 in assets, you're going to be going through a formal probate process with your will. So a trust is different. A trust, you do not ever have to go to court. There's no judge involved unless there's a dispute. But as long as the trust is just being administered and executed, it doesn't ever end up in court. So with a trust, you have control over your assets, and you can give people control even when you're sick, which is a great advantage and why people want a trust. You avoid having to go to court and all the cost and time. If you're wondering, like right now in California, we're talking minimum a year and a half, and that's as everything goes perfectly smooth. And the costs are several thousands of dollars. Whereas with the trust administration, it can move as quick as the trustee can get all the work done. Typically, let's say 6 months to a year is reasonable. And that's just because there's tax returns to be done and things like that. But with a trust, it can be less expensive because you're not having filing fees at a courthouse and all the attorney's fees that you might generate having to go to court. So with a trust, it can be much less expensive to do. And then also with a trust, you might avoid some tax issues or be able to help yourself minimize some. Now, currently, the federal tax rate is, the exemption is really high. So very few people have to worry about federal estate tax anymore, only like 1% of the country. Because it's now currently for couples, you can give out $30 million without any tax consequence. Okay. As an individual, half of that. But for some states have their own death tax. Now, most states don't, but I think there's about 14 of them that have some tax involved in the state that you live. So by setting up a trust, sometimes you can minimize your tax, particularly if you're married. If you're married, you can double the amount that you can get out because there's 2 of you. So using a trust allows you to do that, which a will is harder to make that happen. But a trust you can always use to help minimize your tax situation. Again, currently, very few people need a trust for that purpose, but there are some that do. And that's only because they've raised the exemption so high at this point. Could Congress change that law? Yes, we're all aware of that. So it's just where we are currently. But trusts can help, and that is a reason why people might use them. Next slide. All right, how about healthcare documents? When we talk about those, what are they? So there's three main healthcare documents. There's the power of attorney. Many of you may have heard that term be used before, but this is a power of attorney for your finances. And the purpose of it is if you are unable to deal with your finances, who are you going to leave in charge of that? Now, many of you say, well, my wife will do it. We're on joint. What about how does she collect money from the VA? You have a stroke, you can't talk. They say, put him on the phone. He can't talk, he has a stroke. Sorry, we can't talk to you. Do you have a power of attorney? Sure. Did he sign it letting you do it? Sure. Send me the power of attorney. Social Security, any government agency, somebody who owes you money and you're trying to collect it, even if it's your employer, anybody that you want to be able to help you with your finances if you are out of commission, maybe for a month with a heart attack, recovering from that in a hospital. Again, none of us want to think about it, right? But remember, it's not you that's going to suffer the most, right? It's the people around you, because they're going to try to help you. They're going to be coming and saying, we have to help this person. They are our loved one. This is our child. This is our brother. This is our sister, my best friend. And we haven't provided them the tools. So they end up having to go to court, spend lots of money, maybe out of their own pocket, to try to help us, because the doctors won't listen to us and nobody will give us authority to do what we need to do. So a power of attorney, you're going to name maybe your spouse, somebody else, have backups, and you can name several backups. It's always good, again, to have one person in charge at a time. Lack of that keeps it from confusion. It keeps you out of court because there's less conflict, and that person's able to act. If they can't do it because they're sick, they just don't want to, whatever reason, they can decline. It goes to your next person you named in line. So, but a power of attorney is only while you're alive. So when you die, your power of attorney ends. It's for while you're alive. So when we think about estate planning, it's not just when after your death, it's today. What about the 18-year-old who gets in an accident and you're the dad and you want to help? Do you need a power of attorney? Sure. You call his work and say, hey, I need to help my son. Can't you put him on the phone? He's unconscious, right? Landlord of your son, I can't do anything. You have a power of attorney. You say, here's the power of attorney. I'm speaking on his behalf. I'm solving all these problems, and he's going to recover in a month. Great, 2 months. But what happens? In real life, I get calls. The attorney, you call the attorney because you get stuck. Nobody will talk to you. They're evicting him. They won't give him this. They won't have that. And now you're spending thousands to try to solve and help that problem. So power of attorneys for everybody over 18. How about health decisions? Same thing. Realize that we have HIPAA. It's a federal law that says that the doctors and medical professionals cannot share any of your health information with anybody, not your spouse, not your best friend, not your, kids. Now, does it happen sometimes? I get clients who say, oh, I go and the doctor, let me know all about my daughter. I get it, but you're also going to find situations where they won't, because the law says they're not supposed to. You're going to run into walls. So how do you avoid that? So a HIPAA authorization is where somebody signs it saying, I give these people in writing the authority to get health information about me. So when you send away that 18-year-old to college, and even though mom's been going to the doctor with them for all 18 years, every doctor appointment, When you show up and there's some emergency, they're going to tell you, I'm sorry, ma'am, we can't give you any information. Wait a minute, this is my daughter. Yeah, we know. We can't. Law says we can't. Go hire an attorney. Yeah, that's going to cost $5,000. Yes. And I'm grieving and I'm scared. Yep. Or you show up with a one piece of paper. Here it is. They're like, here you go. Open the doors. What do you want to know? Here's all the decisions immediately. So huge, important document, right? For your loved ones to have, for you to have for them, not just for older people, everybody. So a healthcare directive in some states is referred to, you might have heard like a living will. It's kind of a confusing name because it's nothing like a living trust. It has nothing to do with your stuff. So a healthcare directive or a living will is all about your healthcare medical decisions. In that document, you authorize somebody to talk on your behalf when you can't, make decisions for you when you can't, and get the information when you can't. So when my wife got cancer, and I'm glad that we have these documents, I'm an attorney and I'm her husband, and I still was not going to be able to get anything that I needed done, right? I needed to have this one piece of paper that luckily she had signed, and there were several times when I used it because I needed information. And when I needed it, I could show that. Otherwise, they wanted a signature from her. And when she was sick and weak, I would have had to drag her to the hospital to get copies of tests, to get documents. I would have had to have her sign things. But she had already signed it. So I could go and I could get all those things. So many times it made my life, as hard as it was, I was so grateful to have the documents that we had through all of that process and through all of the illness and obviously the passing. So these things that we shared, it made me be able to help her. And that's what these documents are about, is making it easier for our loved ones around us and our close friends in times when they're going to want to help us. And I believe that's what it's really about. That's the healthcare documents: power of attorney, healthcare directive, HIPAA, what we call authorization or waiver. Okay. Next slide. So what do all these documents ultimately give you? They give you a peace of mind, right? They give you so you can feel like you have these situations covered, and especially that you've taken care of your loved ones, the people closest to you. If you're in a long-term relationship, you're not married, wow, how important are these documents, right? You have, maybe you're single and people think, oh, estate planning is only for married people. Well, if it's only for married people, who's going to help you when you're in that crisis? Oh, all my best friends will show up. Yes, your best friends will be at the hospital and they'll be locked out. They'll be told they can't help you. They can't give them any information, and you're unconscious. But if you've given those best friends this legal document, they can actually help you when they want to. They can step in because they're going to one way or the other. They're all going to pitch in, hire an attorney if you're on life support, and you know they're going to do it. So you can provide them that for free. You can provide it to them. Allow them to have the tools that are going to help you at the most critical times. So we have two different things on our platform. You could choose a will plan, and the will plan is going to include the will. It's going to include the powers of attorney, those healthcare documents, the healthcare directive, okay? And you could choose a single will plan or a married will plan, or you can choose a trust. And if you choose a trust plan, it's going to include a trust and a will. Now people are like, wait a minute, why do I need a will? I'm getting a trust. You have to have a will because with a trust, remember I told you, you're going to have to actually put all your assets. You have to fund the trust by changing the title. So on your house, you're going to have to do a new deed, and your name's going to be on the deed, but it'll be as trustee of your trust. Okay. If you want a particular bank account in that trust, you're going to have to change the title so it says your name is trustee of the trust. Because when something happens to you, your trustee steps in because the asset's in your trust. But what if you forget something? What if there's just one thing or two things that you don't get in the name of the trust that are only in my individual name? The will that you're going to have with your trust plan is what's called a pour over will. What that means is that the will just says, if there's anything in Craig's name, my name out there in the world, I want it to go into my trust. Okay, so that's what your will says. Everything goes to my trust. My trust is my sole beneficiary. The trustee collects it, and then the trustee has to follow the trust. So the trust says who gets what. The will does not. Not for a pour over will in a trust plan. Then you're going to get your power of attorney and healthcare directives. And again, you can buy a trust plan for one single person or a trust plan for married people. And when you go through the platform, there's even on our website or even on your phone, it's going to have a little quiz for you. And if you're like trying to decide, should I get a will? Do I need a trust? It helps you by asking you questions and getting you to think about some of the stuff that we're talking about today. And then you can choose which plan you want. And then you begin to answer questions. And if you want, you can stop at any time and come back and keep working through the questions until you've answered all the questions. And a document, beautiful document, gets mailed to your house. All the documents, you get to read them. And then you will have witnesses and a notary notarize your signatures on them. The witnesses have to be people that are not named in your documents. In other words, you can't have your son, who you're giving your estate to, notarize nor witness your documents. You can kind of understand why. That they're trying to avoid like somebody unduly influencing you to make them a beneficiary, right? So it needs to be somebody you trust, but they're not somebody you're leaving anything to. Our platform, again, if you want a notary to come to your house, there's a partner, we partner with those. You might have a free notary at your credit union or bank, whatever. You could use any notary you want or have them come to your home. You have to have two witnesses, maybe they're close friends, whoever. The mobile notary sometimes can provide people if you want, but you do have to have all that. But then the documents executed, you can have this peace of mind and know that all of those things are covered. Let's go through and talk about how an estate plan is not just a one-time thing, and it is for everybody, but at different stages of your life, you might need different documents. The other type of plan we have is for young adults now. So if you have that 18-year-old who like doesn't need a trust yet, doesn't need those things, but wants that healthcare directive because they're going to school and they want to name their mom to be their healthcare directive person, the person making health decisions, power of attorney, that we have on our platform too. Very reasonable. So you can do it for your son or daughter if they're leaving home, or to name and cover, take care of everyone. So every stage of life. Let's look at that. Go ahead. All right, move on to the next slide. Sure, let's talk about Alex. So Alex represents all of us, all right? And we're gonna walk through Alex's life. Try to imagine yourself as Alex. Also, maybe think about other people in your family. So people that you care about, your friends, your family. We're all Alex, and we all have different milestones and things that happen in our life that might affect our estate planning choices and when we need to change our estate planning throughout our lives. Next slide. All right. So the first one is, luckily, Alex is like a really hard worker. He's very independent, right? So he decides and he goes out and gets his first great job. It's a salary. He's getting money. He has a little bit of money in his bank account, and he's starting to grow that. This is, and so Alex has started his life. He started to have things happen. And let's go to the next slide. And even he eventually decides that he wants to adopt his first dog, Max. So he's starting his life. What does Alex need at this point? Maybe Alex thinks about his estate planning and realizes that a will would help take care of the fact that he's starting to build up a little bit of savings. He has maybe a retirement plan, and he's a dog to take care of. And he's beginning to think, if something happens to me, I want to make sure that Max is taken care of. Next slide. So for this stage of his life, Alex also thinks about things like he enjoys traveling and rock climbing, and he knows that sometimes he has injured himself. He begins to think about, as part of this estate plan, I should really do a will. What if something happens to me? He also thinks about his dog, taking care of him. Then he begins to think about, what about if I was in the hospital, right? If I'm unconscious from falling off a cliff, even though I'm young, I'm probably going to recover. My parents are going to freak out, right? They're going to show up to the hospital and the doctor's not going to communicate with them. I should do a healthcare directive, right? I should do a power of attorney. So he decides to contact and be part of Trust and Will. He goes on our platform and he chooses a will plan. And as he goes through it as a single person, he creates the will, he creates the power of attorney, the healthcare directive, and all of those things are mailed to him and he gets them executed. And now as he travels and does things he needs to do, he knows that he's provided his parents, his close friends, and even his dog with protection and ways that they can help him if something were to happen to him. So really it's a gift to the people he loves the most. And maybe you know a lot of people, I would think you know a lot of people like Alex, and that are out there that could use that type of estate plan. Next slide. What happens next for Alex? Luckily for him, and with a little help, maybe a lot of help from his parents in prodding, he finds Mrs. Right, right? And he falls in love and wants to get married. And marriage is another big milestone. So even though Alex has this great estate plan in place, now he's getting married. He's thinking about, I'm responsible for somebody else, my spouse, and my spouse is responsible for me. And we want to help each other. We want to care for each other. So now maybe I want to name my spouse as my healthcare directive instead of my mom. Maybe mom's going to be an alternate. Kind of tough on moms, right? But that happens. Maybe she wants to name me, and we start to plan a life together. And now we go on and we get on Trust and Will, and we make a will plan maybe for a married couple. And we go through and create new documents now that our life has changed and our legal status has changed. And they're going to now serve us at this point in our life. Next slide. What comes next? Babies, right? So now Alex is excited. He's expecting his first child. A lot of us can remember that. We're nervous, scared, and super excited. But with all that also comes like, wow, this is really adulting. But Alex has been planning and doing the right thing at every step in his life. Now he and his wife say, you know what? We need to update our estate plan. I mean, we have nothing in our will about a child. So now we want to make sure our will covers a guardian for our child, right? If something happens to both of us, who's that going to be? And we think about it and we share our values and we share that. And we think about an alternate person because we never know. Maybe we name my sister and we're really close to her, both of us. But guess what? We spend weekends together. We go on trips together. What if all three of us are not available? We need to name somebody else. So we think of several people. And now we change the estate plan again and make it fit because we have a child, somebody else we're responsible for. Next slide. What comes next? A lot of us, then we go out and decide that I've got a baby and I've got a dog and I've got a family, and now maybe I'm going to get my first property, a first home. This again makes me think more deeply. So Alex starts to think about, okay, now I know on Trust and Will they talked about a trust, and now we're getting this house. Maybe we need to look into a trust plan. And so he decides to level up his estate planning and think, okay, with the trust, I'm going to now deed my house to a trust. We're going to have a family trust. My wife and I are going to be there as the trustees. We're going to provide for our minor child right now and name a trustee that would manage the house and the money for our baby until she's old enough, right, to be an adult. And we're going to have her be obviously the beneficiary, but we need somebody to be in charge because she's not old enough. perfect time to have a trust. So they do that. And this trust serves them for many, many years. But next slide. Our baby girl turns 18. For some of us that have lived this, it feels about like this slideshow too. It goes that fast. Unfortunately, it feels like that. So now all of a sudden, our baby's 18. Does our upstate plan change? Well, now we start to think about she's going to go away to college, our baby. And so he knowing Alex now and having used and been a member of Trust and State for many years, knows that she should have a healthcare directive, because when she goes away to school, now that she's 18, she's an adult and they might not listen to us. We need to have that done. So his daughter does a young adult plan and gets a healthcare directive and that power of attorney and all of those documents. So now if something happens, Alex is able to help his daughter in that situation, and she's protected. She's not left in a situation that when you're in that crisis, you're having to run to get an attorney, because you already have your documents in place and you're prepared. And that can be obviously worth more than all the money in the world. And you have also helped, given this gift, to the people that mean the most to you around you. And it's not your stuff. It's not your stuff. It's about your relationships. It's about making sure that those are strong. It's about not causing them more stress and more grief than is necessary. It's about minimizing that for the people that you care about for a very reasonable cost and easy to do. Now, what happens next in our lives is, Alex, move on to the next slide. So now, maybe like many of you on this presentation listening, you might be like Alex, where now he's at, like his daughter's more independent. Everybody's kind of very independent now. And you're at a different point in time. Maybe you're looking at retirement, and now maybe you have some tax questions. So now you need to look at, is my plan going to cover all those situations? What's the death tax in my state? What's the death tax in currently at? Am I okay? Well, federal, I can, like we said, federal, we're under 30 million. We're probably good. Single person, we're under 15. We're good. No tax problem. But what about in our state level? What are they? If you're in Massachusetts, it's $2 million. So if you're in California, there's no death or estate tax in California. They have what's called a pickup tax, but in other words, it's tied to the federal tax. So in California, you don't pay any tax unless you're in that 1%. That would be different. But he starts to look at, what do I need to do? Do I need to make any changes with my trust? Maybe not, but maybe. So I want to look at that. Next. What about end of life? So now I start to think more carefully about, what do I want to happen? And am I planning for my burial, my funeral, my memorial, writing those things out, sharing my family, my values, and maybe I need to make my estate plan conform to that. So do I have the right person in charge to be the executor, to take over, make decisions? Have I authorized that person to bury me or to cremate me or to do whatever they choose to do? Either way, I need somebody who has legal authority so there's no conflicts. Again, that's part of my values that I'm sharing with the people closest to me. My friends are going to want to come and have a memorial. Have I empowered them to do that? How have you done that? You have to do it legally. So you look at your estate plan. Are they in your documents? Is it the same person that you put in your document 20 years ago? Are they still around? Do you have alternates named? How are they? Is that still who you want? So you start to think about these things as that time in our life happens. Next slide. So you also think about giving back maybe. So at this point, you think about maybe charities. And in his case, Alex thinks about some of the local food bank where he volunteered over the years, and he has a soft spot for them. Maybe it's a church that you've been involved with. Maybe it's an adoption where he adopted Max and he decides, I adopted my dog so many years ago. I love Max. Other people should have that experience. So maybe you think about, how should I include charities in my giving? And you look at that, and that may cause you to want to make changes to your plan. Next slide. So with that, you have the opportunity to do giving in many ways. You could open up what we call an advisor fund. If you have a donor advisor fund, you can do planned giving in your will. You could do it in your trust. But the most important thing is that if that's what you want to do, this is a time to think about it, is through those documents. And of course, remember that charitable giving, you can give unlimited tax-free, right? So particularly like if you're trying to plan, you might give the max that you could give to your family, and then the rest is left. So the 1% know how not to pay tax. They max out what they can give to their family. The rest of it goes into a foundation or a charity. So it's one of the reasons why the federal government doesn't collect a lot of tax for people that plan. So it's always the people in the gray area that don't plan. They get caught, but for the most part, they don't collect a lot. But thinking about us planning, who do we want to leave to as far as charities? That's part of our planning. Next slide. Okay, so you want to figure out where you are in your own planning, assess what your needs are, who's your family, and what strategies are you going to use, and you want to keep your plan up to date. Next slide. So removing traditional barriers, that's what we're all about. So trust and will is about making it less expensive so that every single American can afford doing estate planning. It shouldn't only be for a few, because everybody has family and friends. If you have family and friends, you are rich. Again, if you have family and friends, you are rich and you need an estate plan. Even if you don't have money in the bank, even if you don't own the property you live in, you are rich if you have family and friends. And that's what the estate plan is about. Next slide. So as you think about the benefits of trust and will, it's all online. You can customize, personalize the documents by answering questions. It's state specific to your state. So when you go through online, one of the questions it's going to ask you is, what state are you a resident of? Because every state has different laws. And so the form, the wills and trusts will look different for each state and have different laws, the healthcare directives, etc. So when you choose which state you live in, it's really simple. Look in your wallet or your purse, and what does your driver's license say? And you say, yeah, but I travel. I spend 5 months here, and my dad spends the summers in Wyoming. He spends winters in Palm Springs. But where does he vote? What's on his driver's license? That's the state that you reside, even if you aren't there all the time. Where you vote is your legal residence. And so that's the one you'll choose as you go through the estate planning and answer the questions. If you need help from an attorney, online, you can connect with an attorney locally in your state. And yes, there's an additional cost for that. It's very reasonable. Most people don't need that help, but every once in a while you get a question or you need one. You have access anytime you want to an attorney who's licensed in the state of your residence that's nearby. You could schedule in person, on the phone, over the internet. It's great. That will work around your schedule. But for most people, as they go through the questions, they're able to do it without any help from an attorney, and that greatly keeps their costs low. And it's simple. So it all depends on how complex your assets are, your situation is. But for most people, you're going to find that it's going to serve you well. Next slide. So we talked about Alex. We have more than 500,000 Alexes and Alexises and whoever out there that have used trust and will. These are a few of them. and what they have to say about how it has helped them. These are married people. These are single people. These are people from all walks of life, from all age groups, from all 50 states. We have people who have used our plan in every single state in the United States and can get on and get documents done. So we hope to make it easy as possible. You'll find that as you go through the questions, they're super easy to answer, intuitive. And if you have any questions whatsoever, you can get a hold of our customer service, and they are excellent. No cost for that at all. You can chat with them online. You can talk to them on the phone. And if you get stuck as you're going through the questions or want to understand the process better. But most people are able to do it, in a very short time. A lot of people do it in, not all at once. They sit down for a few hours and start putting together their account, their information. But eventually they get it all done, and they get it sent out to them in the mail, a hard copy in paper, which then they can get executed, signed before a notary, and you can have that relief that you have finished a goal that probably most of us have had for a long time, and now we're finally going to do it. If you need to update an old will that you did, can you use Trust and Will? Yes. Come to our site and you can do a new will, update it. You can update an old trust by doing what's called a restatement of trust. So yes, you can always update. You should update your documents, and we are able to accommodate those types of updates. Next slide. All right, thank you everybody. And as far as how to get started, you can reach out to the organization that invited you, and they can help you get you started with working with Trust and Will. All of our costs are right online. They're transparent. And now you can even go on your phone. So there's no excuses. It's easy, and you can work a little at a time. And we hope that all of you will be able to use our services, and that they'll benefit all your families the way they have mine.
Thank you so much, Craig, for breaking all of that important info down. We have about 5 minutes left of the session. We've had quite a few great questions come in. So let's shift gears and spend time answering one or two. If we didn't get to your question, don't worry, you will get the recording after this session. And yeah, as Craig mentioned, we encourage you to follow up with the organization who invited you today for next steps. But let's start with Jessica. Had a really good question. She wrote, can you put a home that has a mortgage on it in a trust, or will it cause problems with the mortgage company when the deed changes names?
No problem whatsoever. You can imagine most Americans have mortgages, okay? So yes, you can have a mortgage on your home. You can record a deed. It won't bother the mortgage companies. They're used to seeing this all the time. So no problem there. You should definitely do it. You all know that your equity in your home is probably a big part of what you have, right? And it's growing all the time. So make sure that you do that. Have it in a trust. That doesn't mean when you pass away, the mortgage is not going to go away, right? That'll have to be dealt with, but the house could be sold for more money and that get your equity out. There's lots of things that could be done at that time, but absolutely make sure your home is in your trust, and it's a wise thing to do.
Awesome. Another good question that I'm seeing here is, how does a client conclude if they need a simple trust or a complex trust, and how do we educate the client on which one they need?
So in our trust flow, you're going to see that it's pretty straightforward. If you're married, have kids, or you're single and you know who you want your beneficiaries are going to be, it can serve you. Now, complexities. If you have multiple businesses, interests, and or a complex family situation where you have multiple marriages with adult children and minor children at the same time, Some of those things might create some more complexity. And if that's the case, then you might need to have an attorney make it more customized for your circumstance. But I think that as you go through answering the questions, if you get to something you need a question on, you could always reach out for the attorney help. It's very reasonable. But for the most part, it will work for most people. 90% of Americans it will work for. Now, granted, if you're in the middle of a divorce or you already know that people are going to be contesting whatever you do, or you're in that kind of a situation, then you really have to have an attorney that can help draft something, more specific and protect you in some litigation that you might be facing. But that's not most people.
That's really good to know. One other question we had about power of attorney. Does a power of attorney need to be recorded with a county recorder's office in order to be valid, or is that only required in certain situations? The question itself was specific to California.
Powers of attorney are not recorded. They are presented to banks, institutions when you want to use them. The only time a power of attorney would be recorded is if you're signing a deed or a legal document that's going to be recorded and you're signing as the power of attorney. They're going to want to record the power of attorney also to verify that you have that authority to sign that document. So that's a very rare circumstance. A power of attorney is going to be used for much more things than just signing a deed. More likely, it's going to be used at a bank, other places. So you do not just record a power of attorney by itself. It's always part of some other reason that you're recording it.
Great answer. Let's try to squeeze in one more question. This one is very interesting. It's scenario based. I will do my best to word it. If a will leaves everything equally to 3 children and one of those children passes away before the parents, is it possible to direct that child's share into a trust for their children, the party's grandchildren, instead of passing to their spouse?
Yes, and that's what is the standard or normal process. So that's what our trust would do. That's what the will would do. So under California law and many other states, not just California, if your children die, their share, the term is called per stirpes, but it goes from their share goes to any kids they might have. And the concept there is, your grandkids are left orphaned. So you want to provide for the orphaned grandchildren. The other ones have parents to protect them. But to answer your question shortly, yes, you go on trust and will, you put that scenario in, and that's what you're going to get. Minors are going to be set up into trusts until their funds will be held until they're adults. That's really straightforward. And that's what most people would want, and it solves that problem. And you can even do a will under our program, and it will create what we call testamentary trust for any minors, but it will also go exactly like you described. The only difference is, remember, the will is going to go through a probate, and the trust is not, but the outcome will be the same. The cost of administration will be different.
Really good to know. Craig, thank you so much for answering these questions and sharing your expertise today. We are at time, so we have to wrap up the Q&A. Again, if we didn't get to your question, don't worry. You will get the recording after this session, and feel free to follow up with your contact. They can also ask questions on your behalf and connect with us. Thank you, everyone, for joining today. We hope you're leaving with a clearer picture of what estate planning is and why it matters. And we hope you have a great rest of your day.
Thanks, everybody.
Take care. Bye-bye.